All right, very good. Thank you again, Mr. Mactaggart. Really, really appreciate your effort, the work that you have done on behalf of California's consumers. And the floor is yours to give us an overview on the California Consumer Privacy Act.
Great. Well, thank you so much, Madam Chair, Vice Chair, members of the committee, for this opportunity. I really am grateful for this time. It's a privilege and an honor to be here, so thank you very much. What I'm going to do today is just talk a little bit about the history briefly, and then address some of the more commonly percolating myths about it, and address what I've come to learn is called FUD, the fear, uncertainty, and doubt that is being sown around this act, and then to explain some of the critical elements of CCPA. So just a good reminder for all of us to think about some of the technologies that are eliciting so much passion right now. Really quickly, geofencing. You can draw an invisible line around any building, any location in the country, and track every single smartphone going in and out, keep track of them, ostensibly to advertise. In-home devices know everything that's going on in your home, including if they tell you whether they have a microphone in them or not, whether they're recording you or not. Apps, we just saw 2 weeks ago an article in the Wall Street Journal where women trying to get pregnant are putting their most intimate details of their life into this app, and within seconds of them putting the information into the app, the information was being transmitted to Facebook unbeknownst to them. They didn't even have to have a Facebook account for that. The potential for voting manipulation is high. You know, cars are essentially data, gathering machines on wheels now. They know if you go to the gym, if you go to a fast food restaurant, what time you get to work, what time you leave. And as this information has a tremendous amount of value. And as I like to say, 100 years ago, Standard Oil was the most powerful corporation on the planet, but Standard Oil didn't know everything about you. So what was the timeline? I got this idea around the end of 2015. I spent 2 years researching it, talking to as many experts in academia, advocates in business as I could. That resulted in filing the initiative in November of 2017 and starting to gather signatures at the beginning of last year. Through April and June, I started to have negotiations with this body, primarily with Senator Hertzberg and Assemblymember Chow, though eventually, I talked to a lot of people, and it took a lot of assistance. It wouldn't have happened, I think, if the chair had not been gracious enough to put her weight behind it as well. As I think about it, it's one of the things to think about is when we were gathering signatures, we ended up collecting more signatures than people live in either Vermont or Wyoming. This was a very popular issue. We never polled below 80%. Californians really care about their privacy. There was an opposition committee formed. I just put this up I do think it's an amazing American story. The amount of money raised against us between the companies that contributed directly to us, to the committee against us, and representing the associations. It was over $6 trillion in market cap arrayed against essentially one individual, which is really a sort of a tribute to America, California, that it worked, that this was the result. And many of you were there. That day was the day I won't soon forget that you were presiding, Madam Chair, and the fact that it was bipartisan and unanimous, to me, is a real indication of where this state is at. So what did we actually do? The three main elements of CCPA. One is the right to know what information has been collected about you. We call that the right to know. The second is the right to say no to the sale of that information to hundreds of companies you've never heard of. That's an opt-out right. And then the third is the right to have your information kept safe. In an era of identity theft, that's a really important right. So let's address some of the myths. One of these myths is that it came together in a week, and who the heck is Alastair Mactaggart to think he's a privacy expert? He hasn't spent 20 years working in this space. Well, in fact, I did take 2 years of research to try to talk to as many people as I could. But the other thing is, we built in many ways on the work of experts that had come before us. So yes, I hadn't spent 20 years researching it, but I can read. And there were a lot of great ideas out there. So I'm going to give you one little case study of one very central part of our law. There is this effort called Do Not Track, which you may have heard of. And it started about 10 years ago. W3C stands for the World Wide Web Consortium. And they took a group of true computer experts at the intersection of privacy and technology who came up with this idea that your browser should be able to indicate to companies whether you want to be tracked or not. So it was a good idea. It worked technically. The problem was it was based on, it was voluntary. And so some companies honored it, some did not. The advertising industry generally resisted it. And as a result, it kind of ended up failing. But national experts had worked on this for almost a decade, this DNT, do not track. And here's a list, I think it's a partial list of some of the, for people in this business, these are kind of bold-faced names with respect to the people at the intersection of privacy and technology. Full disclosure, I got this off the internet, so if people are on it who don't want to be, I apologize. And if people who aren't on it think they should, again, I apologize. Now, the next slide I want to bring up is, don't read it because it's too hard to read all the words, but what I want to show you is that the bold underlined parts, this is from our definition of business purpose, are all drawn directly from do not track. So again, we were building on the work of experts that have been working on this problem for a decade. Our definition of third party, again, very central to our law. The bold underlined parts are drawn directly from do not track. So again, one of the messages here is that this thing didn't come together in a week. It took me 2 years. And by the way, we relied on experts who had gone before. Now, another area that's gotten some attention is, who's covered by CCPA? So we only cover business, not nonprofits, not government. And our idea was, let's go where the problem is, and we think the problem is with big business and data brokers. So we have these 3 thresholds: 25 million in revenue for a company, or a company that collects 50,000 pieces of information a year, or data brokers that get over half of their revenue from selling information. Now, the 50,000 pieces of information has gotten some attention and gotten some criticism because people say, well, if you have a small little blog and you're collecting only 137 pieces, visitors a day, you could hit that 50,000 threshold. And our answer is, okay, but it depends what you're collecting from people. If you're just collecting an IP address, you can't actually identify the person visiting because multiple people can have one IP address. So in our law, we say, look, a business isn't obligated to provide that information back if you can't identify the person with certainty. So an IP address alone would not be personal information. That said, if you're collecting 50,000 people's credit cards and financial information, then indeed that is personal information under the law. Now, whether that's the right number or not, in the initiative we had a higher threshold. We had 100,000. And in the initiative we had it just if you were selling information. In the law, the legislature in its wisdom reduced it to 50,000 and its collection. But nevertheless, that's a question for this committee. But the point is, it depends what you're doing with the information. Now let's turn to opt-in versus opt-out. And this is a pretty central part of the law. So let's think about the EU. The chair referenced GDPR, which came into effect last May. So GDPR is opt-in. It's based on what's called notice and consent. And if you've been on a European website, you've seen the little pop-up, how about now? Can we collect, we're going to set a cookie, how about now, how about now? We think there's some problems with opt-in. There's some operational issues. One is sort of this consent fatigue. It's kind of a clunky experience. You get these pop-up all the time saying, how about now, all the rest. The second is there is an element of take it or leave it. If you need to use Uber, Uber needs to know your credit card, it needs to know where you're going, it needs to collect your information. There's sort of this like, well, I want to use Uber, but they need to be able to collect my information. So the fact that they're going to ask me if they can collect my information may not mean as much. I know there's a lot of efforts underway in Europe to kind of refine this, but there's an element to that we don't think gives so much control to the customer. And then there's this innovation chill aspect where you're more likely to give consent to a company you've heard of to collect your information than one you've never heard of. So a brand new company, and Europe doesn't have our sort of $25 million threshold, might have a problem. So we thought there's some operational issues to opt-in. In addition, when we were doing the research, I was talking to as many experts as I could, and some experts advised me, hey, look, if you go to opt-in, you might have this problem with the American legal system and the First Amendment rights of corporations. And because this is the Judiciary Committee, I think it's appropriate. I'm going to get a little detailed here, but essentially, there's a case that I was advised about called Sorrell versus IMS Health. It's a Vermont data case where Vermont passed a law restricting pharmacies' ability to sell prescriber identifying information to drug marketing companies. And the drug marketing companies took it to the Supreme Court and actually won, and the law was thrown out. And what's really interesting here is that I actually just going to put some language from the decision that a restriction on disclosure is a regulation of speech. The sale of information is disclosure for profit. And if the acts of disclosing and publishing information don't constitute speech, it's hard to imagine what does. So the advice I got was, it's not dispositive, it's not 100%, but, you put a blanket restriction on the rights of corporations to collect information, you may be running into this issue where you have a restriction of the First Amendment rights of corporations. Now contrast that with the do not call framework. Now do not call was also the subject of multiple lawsuits, and you all remember you could put your name on a list and say, I don't want to be contacted by telemarketers anymore. This was also challenged. This ended up being a 10th Circuit decision that actually was appealed to the Supreme Court, and the Supreme Court didn't agree to hear it. And this decision basically ended up saying, look, if you're giving consumers a right, that's fundamentally different. That's not trampling on the First Amendment rights of corporations because you're giving the consumer a right to go do something with respect to a corporation. So that's another reason why opt-out seemed a safer bet. I was going to spend all this money. I didn't want to spend all this money and end up in a court fight and lose. And then the final reason why we think opt-out really makes sense is because what's the experience going to be like for the consumer? So you want to be able to tell a corporation not to sell your information. How do you do that? We require that companies put a do not sell my information button that you can click. But you can kind of imagine that might be a little bit clunky. You always have to click that as well. So what we require is that companies have to honor a third-party opt-out request. Now, what does that mean in real life? In real life, I've gone and talked to the browser companies, and they said, well, look, we were doing this for do not track. Of course, if it's a law, we'll do this. We would put a browser extension into everybody's browser, allow you to set it once and forget it. Now, every visit to every website you make, the browser for you will just indicate to that website, don't sell my information. So what have we done? We've achieved do not track through legislation. All that work that those experts did for over a decade, we've essentially achieved do not track by another route. And we think that's a really momentous step for this law. We think that that is the end of the large companies tracking you across the web. And what I really like about it as a business person is I think it's simple for consumers. You don't have to do very much. Once you just set that in your browser and forget it. Let's now move to advertising, which also has been a little bit contentious in the sense that we permit advertising. The law permits advertising. And, there have been people who've been concerned about that because they say, well, they can track you through ads, and then what are you doing? You haven't really done much. And the point is, well, if we don't permit advertising, we kind of do wreck the internet. So you've got to have some kind of balance. But to go back to your point is, where's the balance? So where we drew the line is we said, okay, you can do the ads, but you can't resell the information. So a little quick tutorial. When you see an ad online, that means your personal information has been, at that moment, auctioned off in what's called a real-time bid to hundreds or thousands of companies. Every time you see an ad, whether you click on it or not. And in many cases, sometimes most cases, that information is retained by the winning bidder and the losing bidders, which is how your information just gets propagated just by being on the internet. So what our law would say is, sure, you can still conduct the auction, but the information essentially stops. It dies at the recipient. The losing bidders can't retain it, can't reuse it, can't resell it. And so, again, we were trying to strike this balance that you were alluding to earlier. How do you permit commerce, but actually put some reasonable limits on what can happen to the information? Additional rights under CCPA, we give the consumer the right to delete information they've posted. That has to work with the First Amendment, so there's not a European right to be forgotten because that won't work in this country. We increase protection for children. So the age of opt-in is increased from 13 to 16. Having just spent all that time on opt-out, you might be saying, what's all this about? But it is because children are treated differently, so that they're more of a protected class. And then companies, we say that companies can't discriminate against you if you say no to the sale of your data. So you can't all of a sudden say no to your cell phone company, please don't sell my data, and get a $300 a month charge, on your cell phone, which would essentially coerce everybody into saying yes to the sale of their data. Enforcement has been a hot button. AG enforces the act. We have a private right of action, so consumers can sue for negligent data breaches. And what those are there are three safe harbors. If a company has encrypted the data, If they redacted, that means took your name out of the data set. Or if there were reasonable security procedures in place to protect the data, then there's safe harbors from the private right of action. Otherwise, there's a private right of action for data breach. Essentially, the reason for that is I didn't want to have a situation where a company's doing its level best to comply, and then the Russian government or the North Koreans, hack into the company and there's some liability. So as long as you're doing your best, and essentially if you encrypt it, you're fine, which you should be doing anyway if you're collecting people's information. With respect to AG enforcement, it's gotten a little attention recently. What I would say is this was part of essentially the deal that came together. In our initiative, we had a private right of action for everything, and we reduced it to just the negligent data breach. But we got a lot in return. We got the right to see actual information. The initiative had just had the right to see categories. We got the right to delete. We got the opt-in age increase. So it was a deal. We did a deal between, we reduced the scope of the private right of action and got better protection for kids, for consumers. I would do it again. I think it was the right thing to do at the time. I still think it's the right thing to do. With respect to changes, people have asked me about changes, and this is the committee that will decide. I'm just a individual, and so many have asked me, am I worried about where the law stands now, and is this now time for business to come back in and gut it, and do you feel like a fool? And what I say is absolutely totally on the opposite. In my travels, having met the people who the laws, in whose hands the law rests now, I feel even better about having done it, and I would do it again in a heartbeat, because I feel like the people I've encountered really want to make this the best law for the state going forward. And of course, there are going to be changes, and I'm not some diehard who says these things came down from Mount Sinai. I'm willing to, if anybody wants my opinion, I'm willing to give it to. So I'm going to close here with where I think CCPA is in a historical context. If you think about the rise of the auto safety movement in the 1950s, by that point, cars had been mass-produced for 40 years on production lines, and safety really hadn't gone anywhere until, unsafe at any speed and nadir, and all of a sudden people were like, oh, maybe we should pay attention to safety. If you think of the rise of tobacco and anti-smoking efforts in the 60s, cigarettes have been mass-produced for 80 years by then. This is an established technology. If you think about, auto emissions and trying to get cleaner air in the 70s, this state obviously took the lead, and people were tired of not being able to see across Los Angeles. And if you think about all three of those examples, we the people, acting through our representatives, said, hey, this isn't acceptable anymore. This is an established technology, but you, industry, can and should do better. You need to do better. And at first, industry resisted in all those cases, vociferously. But now just try to imagine selling a car without seatbelts or without an airbag. It's impossible to imagine. And guess what? Business made plenty of money along the way. And it survived, and it thrived. And I think we're in such a situation right now with respect to privacy. I think that California is now a worldwide leader in privacy. The feds may or may not do something. They may or may not preempt. Other states may or may not pass. But today, 1 in 8 Americans is covered by this law, which goes into effect next year. And I think there's a awesome responsibility in this room in your hands, because we are at where this state is so often. We're in the vanguard of really important societal changes. And actually, this is frankly international. I mean, we're a country. We're the 5th largest economy in the world. It's entirely appropriate that we're here. There's a tremendous amount of technical talent and political talent around the room, and I'm humbled to be part of this, and I want to say again, thank you so much for your time.
Thank you again for your work in this effort. It really was that one person kind of stepping up in an issue that many of us have found to be, the more we've known, frustrating. And I want to, again, emphasize the incident that you just referenced. 2 weeks ago, we learned that women who were trying to perhaps get pregnant and putting information into their Fitbits that described their menstrual cycle so that they'd know when they were ovulating, that Facebook would get that information without anyone's knowledge or permission is quite extraordinary. And I think an example of some of the more outrageous but still existing potentials. I mean, I think about it, if you don't want your mother to know you're trying to get pregnant, you certainly don't want somebody who's a complete stranger to have that information either. And this is the kind of thing that we are seeing. So your efforts really have, I think, made an extraordinary difference, and I want to thank you publicly for doing that. I do have one question. And I realize that this was a white knuckle, and both a knuckle and white knuckle effort, because to get those industries, the $6 trillion worth of opposition to come to the table and to resolve this with it before the initiative was quite an effort. But I wonder if you could share with us what more you think needs to be done to effectuate your intent, recognizing there were compromises made. But if you were, as I often ask, the master of the universe, what would you do more to effectuate your intent?
Well, you know, I think the part that was sort of the most painful for me giving up was the whistleblower. We had a whistleblower provision in that. And that was hard because I felt like sometimes deep in the bowels of these companies, it's going to be hard to figure out what's going on, and you're going to need someone sophisticated to take a chance. So that's kind of an area, I think. I think that there are some clarifications that could be made. Like, for example, I know Household's gotten a lot of press because Household was put in at the last minute, wasn't in our initiative. There's some real reasons that it needs to be addressed, but at the same time, it does need a definition. So there's things like that. So I think there's some clarifying areas. But honestly, I mean, I will say that the odd circumstance of the having that initiative and having something where the companies understood that this was polling at 80%, and they understood that to get 80 down to 50 was going to cost, A, a tremendous amount of money, but B, was going to require them to be spending money against their own customers, something their customers cared about. They knew that was kind of untenable. So it was an odd dynamic, which I don't think would exist in other initiative situations. And so we did have quite a lot of power to sort of say this is the way it's going to be. And we ended up, I think, with a great law.
Thank you. I will start with Mr. Vice Chair and then Senator Money.
Thank you, Madam Chair. Kind of want to ask you a question. Is your information, from a legal standpoint, as far as you're aware, who owns your information? Is that a private ownership? Is it a proprietary? Or at what point does it become public domain? Are you familiar with any case law that articulates when your information is your own and ownership transfers upon a series of events? I'm going to answer that. I'm going to look back at my lawyer just to make sure. James Harrison's here. If you want to come up and answer as well. But in the meantime, I did ask the chair if it was okay if he came up.
No problem.
His name is Mr. Harrison, James Harrison. But what I'll answer for now is, you know, one of the issues that we encountered is when we talked about, one of our ideas was to make it a property right. And the issue there is we ran into advocates who said, oh, you can't make it a property right because you can alienate a property right, and this should be something akin to a civil right that you can't alienate, right? But my understanding is, at this point, that the companies own your data, which feels weird, doesn't it? Like, it feels weird that you would give all that information to them and then they own it. I don't know if do you know any case law?
I'm not familiar with any case law. One of the challenges we encountered in drafting the measure is how to deal with information, some of which is voluntarily posted, sometimes with restrictions, such as if you limit your Facebook settings just to your friends, sometimes without any restrictions at all. And once information enters the public domain, it's very difficult to attach any sort of property right to it.
So it's clear this is the Wild West area of the law, because it's not clear as I'm aware of it. Now, going back to the do not call list, was that a national clearinghouse or was that a state? What was?
So what my understanding, and I did some research on it, was that it was state by state initially, and the states did it, and then I think eventually there was a national, but it started with the states, and as I believe that mainstream marketing was a state case.
So in your odyssey of pursuing this, did you contemplate that maybe a clearinghouse style at the state level would take away all the uncertainties for those that don't want to participate in the information exchanging technology, akin to a do not call list?
We did, and frankly, one of the things we were doing was, when we were doing the initiative, we were trying to craft something that would survive without any obvious vectors of attack against it. And so the idea of creating like an agency or something was going to
Clearinghouse.
take some money, and we knew that that would be something for the opponents to be like, oh, you're just trying to build an agency, so they could maybe attack us on that. So we were trying to get something that essentially carried its own weight. So that's honestly why we didn't pursue that route.
Okay.
Would you do me a favor? Would you identify yourself for
Yes, I'm
for
sorry.
the record?
I'm James Harrison from Remcho Johansson and Purcell.
Thank you. Thank you.
And my last question is, because I'll give you a quick example. You've heard of Alexa. So we have an Alexa speaker at my house. Well, my kid's name happens to be Aleko. You can imagine the problems that we have when I'm yelling at my kid and Alexa says something in response. So it makes for some interesting dialogue in the house. But in terms of jurisdiction, given that we have essentially interstate commerce situations here where entities are located in different parts of the nation or abroad, transactions are completed in the United States, how does the jurisdictional authority issue play out if there is a opt-out or even an opt-in with entities that are located outside or even internationally? How would they just simply be in violation of California law?
Well, I'll let James talk to more of the details, but essentially, since we give California consumer rights, that's anybody doing business in California has to give the California consumer their rights, and I'll let you talk about interstate commerce.
Right. To address that issue, the law includes an exception to ensure that if a transaction occurs entirely outside of California, even if it involves a California resident, so that the business that obtains the California resident's information obtains it when that resident is out of state, sells it in a transaction to another company that's also out of state, that is expressly excluded from the scope of this law to avoid a Commerce Clause challenge.
Thank you.
Thank you. Senator Monning.
Thank you, Madam Chair. I want to thank Mr. Mactaggart for your work on this, particularly your collaboration with the legislature to achieve what you outlined and is now law or soon to be law in California. On this last point, is there any way to protect a California resident consumer using their computer out of state? You raised the concern of the Commerce Clause. Moving forward, is there some way we could look at that and buttress the right of a traveling California resident?
It's certainly something that could be pursued further. I think in most instances there will be some contact with the state of California. I think it would be unlikely that you would have too many instances in which the entire transaction takes place out of the state of California and there's no contact between that business and the state of California. But it's something that the committee could certainly pursue further.
Thank you. So in the area of auto emissions, Mr. Mactaggart showed us some of our legal government consumer protection advances through the decades. One thing that we've done with our air standards is auto manufacturers now build their cars to the highest standards. So we set the pace, and then the vehicle sold in Oklahoma or Kentucky has the same protections because they're not going to manufacture different cars. Is there any movement towards other states adopting what we've done, and or where are we at with federal government looking at this?
So I've been to Washington a couple of times to talk to various members about it. I think it's not lost on anyone that 20% of the House majority is from this state, including some important committee chairs. And what I've heard from everybody thus far there is that a bill to preempt California with a weaker standard won't happen. And they won't let it happen. I think there's plenty of national example. For example, HIPAA, the health law, GLBA, Gramm-Leach-Bliley, the financial law, are both what they call floors, not ceilings. They set national standards, but they let the states go beyond, and I think that's an appropriate thing to do here. My final point on this is that I think tech is trying to sell this worry that, 50 different standards, we can't possibly comply. And my answer to that is, to the point you just raised, I think it's going to be absolutely untenable for a consumer-facing company on January 2nd next year to say to the residents of New York or Illinois or Texas, hey, by the way, all the people you know and your friends and relatives in California now have rights that you don't have. I don't see how that's going to happen. So I'm not particularly worried about the 50 states thing. And even if there were 50 states, look, there are 50 different data breach laws, and you know what? Business keeps on going.
So a few years ago, I carried legislation unsuccessfully looking at the auto industry. We now have computers on wheels. You buy the vehicle, it's yours, you own it, but it continually is generating data that is used by insurance companies, sold to insurance companies. They can track your routes and know that you go by this Denny's restaurant every day, and then you start getting emails or Facebook postings about Denny's restaurant in Santanella or wherever it may be. So I own the vehicle, I own the computer, but I don't own the right to opt in or opt out or control. Do you know, does this law protect data that's being generated from our vehicles?
Yes, what you'd be able to tell the company is, don't sell my information. Now, they could still collect it for specified purposes, like for warranty, for that kind of thing, for maintenance, for safety, but they couldn't. And by the way, on that, what's really interesting, I know someone in the auto industry who said, you know how often you buy a new car or you lease a new car and they say, be part of like OnStar or something, and then after the 3 months they say, now we'd like to start charging you. Well, what they've started doing now is if you say no, they still keep it on. You know why? Because the data is so much more valuable for them to collect.
Than your monthly fee.
Than your monthly fee. Right. So they offer to do it for free.
Thank you. And my final question, Madam Chair, it relates to your comment about the BIT device, the application that can allow the owner to track certain health data. But built into that is a connection to a Facebook application, but that doesn't appear anywhere on the BIT piece. How does this law protect the consumer from that scenario, or does it?
Well, if you told Fitbit, in this case, not to sell your information, again, we do have these operational, what we call business purposes, where the data can be transferred. But in that case, if Fitbit was relying on a business purpose exception to transfer the data between Fitbit, say, and Facebook wouldn't be able to combine that data with everything else it knew about you. So it would only really be able to use that data in the context of Fitbit. And so one way to think about that is you go to the LA Times, Facebook can know about you while you're on the LA Times. You go to the Chronicle, Facebook can know about you on the Chronicle, but it can't combine that. So it can't track you, for the consumer who opts out, it can't track you across every page you visit on the web and combine all that into one giant database.
So, and I said it was my final question, but I actually have one more.
We'll give you one more.
Moving forward, when this law becomes in effect, what about data that's already been collected? Can we go retroactively and say whatever data you collected of mine up to January of 2020 or whenever it goes into effect, do we have the ability to reach back to protect data that they may already possess?
No, we want to draw a line in the sand and sort of give it a standing start, and so it's moving forward from then.
Thank you. Thank you, Madam Chair.
Thank you, Senator Wieckowski.
I guess I have a question on your comment on the right to delete. I'm sure consumers like that. The excellent staff report talks about some broad exceptions. There's, security, detection makes sense, debugging, public interest information. Then we have this rather large, the businesses' free speech rights. And all I can think of is that baker with the wedding cake, exerting their right. And I wanted to get your take on that. Is it to make it meaningful for the what I expect, or I think some consumers, of the right to delete my personal information?
So, we live in a country with strong First Amendment rights. And one of the, not to not answer your question, but to answer it a different way, one of the ways to think about this bill is we give the Attorney General a tremendous ability or power to issue regulations in furtherance of the act. And so my intention was not to set something in stone and then say that's a forever thing, because I think this is moving with the times. And so that's the kind of thing where you could say, okay, this is what the regulation means, and then to the extent that you find it's being abused or that it needs fixing, you could probably fix that with a regulation from the Attorney General enforcing is my hope. I think the reason we put it in there is because I was told that that was something you needed to put in terms of being able to not trample on First Amendment rights.
So the way the balancing ball would work is they have my personal information. I ask them to take it out. They say, no, this is a free speech expression. Then I ask the Attorney General to sue for me.
Yeah, I think what would probably happen is multiple people would say, hey, look what companies are doing. They're using this as a loophole. They're saying it's all First Amendment rights, but no one's actually deleting your information, and then that would become a thing. And I think that the Attorney General would step in. Do you have any? Yeah.
Which is, as you know, putting quite a burden on the Attorney General. There is that as well. Any other questions? All right. Thank you.
Senator, I actually want to correct something. Sorry,
All right.
I was wrong.
Please.
One clarification, the text of the measure applied only to information collected after its effective date. That provision is not in the CCPA enacted by the legislature.
All right. So what would the consequences of that be? Would that mean that we could go back retroactively?
In January, you will be able to go back the year. It's a year you can look back a year.
All right. That's very helpful.